Okay, class, settle down now, please. This is very important. I'm not sure if they are ignoring me or if they just can't hear me. Wait, here's an idea. Please, listen up.
Yes, Mr. Know-It-All.
For the last time, my name is pronounced Know-It-All. No et al. The H indicates aspiration, not a dental fricative.
What's a dental fricative? Can you even talk about that stuff at school? Yeah, I don't even want to know what an aspiration is.
Anyway, since it's almost the end of the school year and the final is only 2 weeks...
Wait, there's a final? Yeah, I thought we were just going to do nothing for the rest of the year.
Yes, of course we're having a final. And by your attitudes, we are really going to have to review for there to be any hope of any of you passing.
Rude.
Let's begin with the general philosophy of the legal system. Can anyone tell me some basic goals of the legal system?
Punish criminals?
Well, that's certainly a simplification, but in some aspects, yes. There are essentially 7 key principles, one of which is related to what you said. One of the goals of the legal system is promote order and stability, which is achieved through deterring and preventing crime, which is the purpose of things like prison, time, and other punishments.
What about freedoms? Isn't this America?
Well, yes, but please let me finish before you ask any more of these inane questions. Despite your rudeness and general mongrelry, you do, yet again, make a good point. Another goal of the legal system is to protect what are called the 4 basic freedoms, dating back to the 1940s. These include the right to freedom of speech, worship, freedom from want, and fear. These 4 freedoms outline and serve as a nice basis for the remainder of the goals, which include promoting trade-offs, help people avoid and resolve conflicts, help communities achieve goals, represent the will of the majority, protect the rights of the minority. As should be obvious, all of these goals are interrelated. Promoting trade-offs are crucial to resolving conflicts, and within community development, democratic majority as well as the rights of the minority should be kept in mind. Another trade-off. It seems like this very idea of trade-offs, much like how my ex-wife can never seem to leave me alone, permeates through every goal. The balance between freedom and order, the majority and the minority, and what have you. These ideals set up a...
Professor Know-It-All. Professor Know-It-All.
Yes? Again, please stop
I have 2 questions. Why did you talk about your ex-wife? That was kind of strange. But anyway, what I was really wondering was how all of these goals are implemented. How are we to be sure that the legal system is actually following through with these ideals?
I just was going to explain that, and then you interrupted me. Anyway, yes, that's a good question. The best answer I can give you is the Bill of Rights. I'm not going to go over it in its entirety, but in short, it ensures the rights of freedom of speech, self-armament, but also gives the government some rights as well. Remember the idea of trade-offs, which is the right to repossess private property, although with ensured reimbursal. The general description of rights within legal proceedings and separations of federal and local powers also serve to establish individual rights, but also structuring the government in such a way that it can democratically address concerns on the individual and group level. Well, with that out of the way, we can move on to the interesting stuff, like crime, which is exactly what we're going to talk about next. Unfortunately, the criminal justice system is very complex, so we'll have to keep it quick and simple. The first step in the criminal justice process is, of course, the actual crime, which can eventually lead to interrogations. In such and similar situations, it's important to be aware that you're not required to say anything, and that you have the right to a lawyer, regardless of your ability to pay for one. If it appears that you are free to go, you are. Oftentimes after arrest, and before the aforementioned interrogation or questioning, the police officer will read you your, quote, Miranda rights.
Oh yeah, that silent E is a ninja guy.
As much as I'd love to talk about linguistics and children's television, we have to stay on task. Anyway, before any sort of questioning by a police officer, your Miranda rights must be read in order for anything you say during an interrogation to be admissible in court. The general spiel informs you of your right to an attorney and of your right to remain silent, something we're all pretty familiar with from television. Something people are often less familiar with, however, are proper interactions with the police. During a traffic stop, for example, it's important to remain calm and collected, and most importantly, don't blast the police by NWA. In such scenarios, it's also important to not give the officer any grounds for probable cause. Warrants signed by a judge can also provide this, but in certain cases they are not needed. For example, if you're pulled over and give the officer your driver's license, showing that you are a minor, the officer smells a distinct smell of cannabis, alcohol, or any other substance at a minor, that means you guys shouldn't have nor be using, in addition to the fact that they saw you quickly throw something under your seat once they put on the siren. The officer has probable cause to search the immediate area surrounding your seat, given that your actions point to specific criminal action, drinking and driving, or in the case of the marijuana example, assuming that you are a minor in the state of California, possession and use of marijuana. This specificity is crucial to warrants in general. In order for there to be probable cause, the evidence must point to a specific crime, and a potential search is restricted to specific areas, as reflected by the traffic stop example. Another important step in the criminal justice system to note is the arraignment, which occurs soon after an arrest and booking. At an arraignment, the judge will describe the charges to the defendant, as well as assuring them of their right to an attorney and so forth. Oftentimes, the bail will be set here as well. Now that I've refreshed your memory about the criminal justice system in general, we can move on to the juvenile justice system, more relevant to you all. The first thing to know is that juveniles can't actually commit crimes.
I suddenly have a great plan for this weekend.
But they can commit, quote, delinquent acts, which can be punished by the government.
Darn it.
Oftentimes when a minor first commits a crime, a police officer can simply give them a warning and send them on their way, or even just to make a deal with the parents and a probation officer. If the officer decides to, quote, haul in the minor to the juvenile center, the case is given to the probation officer, who will ask the district attorney to file charges. However, if the charges aren't that serious, the probation officer has discretion over what to do with the minor. But if the charges are serious, the justice process begins. First, there's a detention hearing in which the best place for the juvenile to stay during the proceedings is determined. Afterwards is the jurisdiction hearing, which is like a mixture of an arraignment and normal criminal trial. The judge will make sure the minor understands their charges and rights, as well as let them make their plea. From there on, the trial is conducted like any other trial, with lawyers arguing and making their case and so forth. However, the trial is more akin to a bench trial, in that it is solely up to the judge to describe whether or not the petition or charges against minor are true. After the jurisdiction hearing, if this, quote, petition is deemed to be true, then comes the disposition hearing, which is the equivalent of sentencing in a normal criminal trial. However, in the juvenile justice system, greater emphasis is put on rehabilitating minors rather than punishment. Remember, these are just kids. And in the view of the state, there's a lot more room for change of path. This idea is even evident in the fact that minors can't even commit crimes. There is some idea that the committing of a crime requires an adult mindset. Of course, given this, there's the possibility for a minor to commit adult-style crimes, and with that, adult-style prosecution. Before the jurisdiction hearing, a district attorney can request a, quote, fitness hearing, in which a probation officer will report to the court various findings to determine if the minor should be tried as an adult or not. Well, enough of all this committing crime and doing time. It's time for civil law. What's civil law, you ask? Well, it's like normal criminal law, but without crime, and because of that, disagreements are handled more civilly, I guess? Well, don't look at me. I don't name these things. I just teach you about them. Anyway, the civil court system is structured similarly to that of the criminal system, but with a few differences. There's less emphasis on the jury, as bench trials are more common and juries are to be requested, not necessarily directly ensured. In torts or lawsuits, a plaintiff will file a complaint. A defendant will be notified and the proceedings will begin. There's no prosecutor or anything like that. The state proceeds over the process but has a less direct hand in it, hence the civil aspect. Oh, I guess that's where the name of it comes from. As I am sure you are all aware, you can practically sue anyone, except minors, for anything. This can be for criminal or non-criminal actions, and can result in injunction, making someone stop doing something, or financial exchanges in some way, shape, or form. In civil cases, the punishment often fits the action. For example, if one's slanderous speech or libelous publications results in another's failure to get a job or some other benefit that can be measured financially, potential settlement amounts could be set by this, quote, lost income. Punitive damages may also be used in order to, quote, punish the defendant, in order to deter similar behavior from others in the future. Arbitration and mediation are also options for less formal extrajudicial settlements. And finally, we have family law, which is a subset of civil law. Family law deals with all things familial, from marriage, children, and cheesy game shows hosted by Steve Harvey. Well, maybe not that last one. Given that marriage is most often how families start, let's begin there. In order to get married, you must be unmarried and get a marriage license. Before marriage, it is possible to get a prenuptial agreement or prenup, which usually clarifies financial obligations and duties for the two spouses. In order to end a marriage, you have basically two options: annulment and divorce. Annulment can only take place when the marriage was conducted under some sort of lie or falsehood. Legally speaking, the marriage never happened. In order to end a marriage, you want a divorce. Because marriage has all sorts of financial benefits, divorce leaves all sorts of financial problems that must be worked out. If one spouse needs support and another can provide it, you have alimony. If there are children, child support may be needed to keep an equal standard of living between two households, assuming that child custody is split 50-50 or with some other agreement. On the subject of children, let's don our stovepipe hats and talk about emancipation. To be emancipated simply means to be freed or released from the custody of your parents. There are two easy ways to be emancipated and one hard way. The easy ways are to be married or join the armed forces, which requires parental approval. The hard way is to prove to the court that you are essentially mature and independent enough to be separated and independent from your parents, giving you more personal autonomy. In order to be emancipated, you must be at least 14 years old, be able to make and handle money, and more vaguely benefit from emancipation. It would be, quote, good for you. If these conditions are met, you forfeit your right to be supported by your parents. Oftentimes, this means moving from your parents' house, but theoretically, you could still live there as a legal tenant. Another condition for emancipation is your parents accepting you're moving out. Well, that looks like all we're going to have time for today. I'll see you all next week for the final. Goodbye.